What you are about to hear should concern every American who values the Second Amendment because something has shifted, and it's not subtle. Police unions, organizations that many gun owners once believed were natural allies of the Constitution, are now openly opposing core Second Amendment protections. This is not rumor. This is not speculation. This is happening right now, and Congress is being pressured to act. The question is not whether this matters. The question is whether Americans are paying attention before the damage is already done. Welcome back to the channel. This is Second Amendment Advisor, where we cut through the noise, ignore the corporate spin, and focus on what actually affects your rights. Today's story is one of those moments that future court cases, future elections, and future legislation will look back on and say, that's when things changed. Because when police unions publicly turn against the Second Amendment, the political calculus shifts in ways most gun owners are not prepared for. For decades, gun control advocates have leaned on one powerful talking point: law enforcement supports these restrictions. Whether that claim was fully accurate or not, it carried weight. Legislators cited it. Courts referenced it. Media outlets amplified it. And now, police unions themselves are stepping directly into the political arena, urging Congress to block or oppose legislation that expands or protects Second Amendment rights, specifically measures like national concealed carry reciprocity under H.R. 38. That alone should set off alarm bells. Let's be clear about what this means. Police unions are not individual officers. They are political entities. They lobby. They donate. They negotiate. And when they take a public stance, lawmakers listen. When police unions tell Congress to stop a pro-Second Amendment bill, anti-gun politicians don't hear caution. They hear validation. They hear cover. They hear permission to move forward with restrictions that would otherwise be politically risky. Supporters of these union positions argue that their opposition is about public safety, that expanding carry rights would complicate enforcement or endanger officers. But that framing deserves scrutiny because the Second Amendment is not conditional on administrative convenience. It does not exist to make government jobs easier. It exists to protect a fundamental right that predates the Constitution itself. What's especially concerning is how this opposition is being used rhetorically. The narrative forming right now suggests that armed citizens are somehow a threat to law enforcement rather than partners in public safety. That idea contradicts decades of real-world data showing that lawful gun owners are overwhelmingly law-abiding. It ignores the millions of Americans who carry responsibly every single day without incident. And it reframes constitutional rights as obstacles rather than protections. This is where Congress must act, not react, not delay, not hide behind committee hearings, but act decisively. Because when powerful institutions align against the Second Amendment, silence becomes complicity. Lawmakers who claim to support the Constitution cannot afford to sit on the sidelines while unelected organizations attempt to redefine the scope of a fundamental right. We've seen this pattern before. Rights are rarely taken all at once. They are narrowed incrementally. First, through reasonable concerns, then through temporary measures, then through exceptions that quietly become the rule. Police union opposition provides a powerful tool for that process, especially when paired with emotionally charged headlines and selective statistics. What's missing from this conversation is historical perspective. The Second Amendment was not written with the assumption that all government institutions would always agree with it. In fact, it was written precisely because governments and powerful entities can, and often do, turn against the rights of the people. The idea that law enforcement opposition somehow weakens the legitimacy of the Second Amendment misunderstands the entire purpose of constitutional limits on power. That doesn't mean individual officers are the enemy. Far from it. Many officers are gun owners. Many support the Second Amendment. Many recognize that responsible citizens are not the problem. But when union leadership speaks, nuance disappears. Their statements are treated as collective authority, even when they don't represent the views of every officer wearing a badge. This is why this moment matters so much. If Congress allows police union pressure to dictate Second Amendment policy, it sets a precedent that constitutional rights are negotiable based on institutional comfort. That precedent won't stop at firearms. It never does. Once rights become conditional, they become vulnerable. The debate around H.R. 38 is a perfect example. National concealed carry reciprocity does not eliminate state laws. It does not prevent enforcement of existing restrictions. It simply recognizes that a law-abiding citizen should not become a criminal by crossing an invisible line on a map. Opposition to this principle reveals something deeper, a preference for control over consistency, for restriction over recognition. Courts are watching this closely. Judges pay attention to legislative history, public statements, and institutional positions. When police unions oppose Second Amendment protections, those statements can, and will, be cited in future litigation. That means today's political messaging becomes tomorrow's legal justification. Congress cannot pretend this is just another advocacy disagreement. It's not. It's a direct challenge to how the Second Amendment is interpreted, defended, and applied in modern America. Lawmakers who truly believe in constitutional rights must be willing to say so clearly, even when powerful voices disagree. The media, of course, is already framing this as a victory for common sense. But common sense is not a legal standard. The Constitution is. And the Constitution does not contain a footnote that says rights expire when institutions feel uncomfortable. Gun owners should also understand the strategic timing here. Opposition is intensifying as courts continue to apply the Bruin framework, which demands historical consistency for gun laws. When judicial routes become harder, political pressure increases. That's exactly what we're seeing now. Police union opposition is part of a broader effort to reshape the narrative before courts can fully enforce constitutional limits. This is not a moment for complacency. It's a moment for clarity. Clarity about who decides the scope of your rights. Clarity about whether constitutional protections are permanent or provisional. And clarity about whether elected officials serve the people or defer to institutions when it's convenient. Congress still has a choice. It can stand firm and reaffirm that the Second Amendment is not subject to institutional veto, or it can allow fear-based arguments to erode a right that millions of Americans rely on for self-defense, liberty, and peace of mind. History will remember which path was chosen. What happens next depends on public pressure, voter awareness, and whether Americans refuse to let this issue be quietly buried under talking points and procedural delays. The Second Amendment has survived challenges before, not because it was popular, but because it was protected by those willing to defend it. That responsibility now falls on Congress and on informed citizens who refuse to be passive while fundamental rights are debated behind closed doors. This is not the end of the conversation. It's the beginning of a critical phase. Stay informed, stay engaged, and above all, understand that when powerful institutions take sides, your silence is interpreted as consent. This is Second Amendment Advisor, and we will continue to track every development, every vote, and every attempt to redefine your rights before it's too late.